Hi, I'm Attorney Ben Schwartz, and today we're going to do a video, a short course in 10 things you need to know if you're an attorney handling criminal cases about your fees in Delaware. And basically, by way of introduction for this video, what I want to tell you is that I'm an attorney in Delaware. I'm a managing partner of a law firm with multiple attorneys who handle criminal cases and traffic ticket cases, and I'm responsible ultimately for making sure that all of the cash handling procedures in my law firm are compliant with the Delaware lawyers' rules of professional conduct. I'm also an associate trustee on the Delaware Supreme Court Lawyers Fund for Client Protection, and what I'm going to tell you in no way is a statement on behalf of the Delaware Supreme Court or the lawyers' funds. These are my views and my opinions only, but if you're an attorney in Delaware, this should give you a pretty good idea of what you need to do and what your fee agreements need to do in order to be compliant with the Delaware lawyers' rules of professional conduct. So here's my 10 things you need to know. Number one is always charge a reasonable fee. I can give you the citation to Delaware Lawyers Rule of Professional Conduct 1.5a, and all fees that are charged by Delaware attorneys in connection with representation in Delaware cases need to be reasonable. What is reasonable? There's a whole list of things to take into consideration in determining whether a fee is reasonable under that rule. But suffice it to say, if you are handling criminal cases or a prospective criminal case and you don't know what a reasonable fee is to charge, you can certainly ask around to other attorneys and find out what they have charged in past cases that are similar to the one that you're going to handle. There's a lot of resources in Delaware, and Delaware attorneys tend to want to help one another. So you can, if you're a Delaware attorney, you're trying to figure out what to charge, feel free to give me a call. I can tell you what I've charged in other similar cases, and I can give you other resources to figure out what to charge as well. Number two, never make a payment in a criminal case, a fee payment in a criminal case or in a traffic ticket case, conditional on the outcome of the matter. So basically, the rule that says this is DLRPC 1.5D2. We see situations where someone will get a ticket in connection with an automobile accident. We want to represent them in the traffic ticket case and in the personal injury case. The personal injury case will handle on a contingent fee. We quote a fee for representation in the traffic ticket case, and the client says, can you take that money out of my settlement that I think I'm going to get from my personal injury case? And the answer is absolutely not. It's unethical. Never do it. 3, use written fee agreements. When you look in the rules, the rule that applies is DLRPC 1.5F. When you look in the rules, it does not specifically say use a fee agreement for criminal and traffic cases. It says use a fee agreement for contingent fee cases, but not for criminal and traffic cases. But if you look at the language and look at what's required, it's pretty clear that it contemplates that you're going to use a written fee agreement, so you might as well do it. Number 4, include a statement in the written fee agreement that all advance fees are refundable unless they are earned. This language is mandated by DLRPC 1.5F1. And also along the same lines, if you get to the end of a case and you have not earned the entire fee, promptly refund it to the client at the conclusion of the representation. That's DLRPC 1.15B. 5, structure the fee over the events of the case so as to provide a reasonable basis for determining when the fee or portions of the fee is actually earned. DLRPC 1.5B and DLRPC 1.5F2 require this. So for example, let's say you have a misdemeanor criminal case, you take a fee, you will structure that fee, maybe 25% is earned upon entry of appearance, 25% is earned upon receipt and review of the state's discovery material, 25% on the initial appearance in court, and 25% at a second or final case review. Whatever you do, the structure of the fee, the increments of the fee, and the reasons why they're earned must be reasonable. That's DLRPC 1.5A. 6. When the client pays you a flat fee in a criminal or traffic ticket case, deposit the entire fee, get everything that they paid you, deposit it in your law firm's trust account. DLRPC 1.15A speaks to this. It's client property until it's earned. If the representation is to, in my office we handle criminal cases and traffic tickets cases in other states, in New Jersey, Pennsylvania, Maryland. So in my office, if the representation is to occur in another state, we're going to deposit the funds into the trust account that we maintain for that state. Comment 10 to DLRPC 1.5 talks about a $2,500 rule. And I've spoken to attorneys in Delaware over and over, and they say, well, if the fee's under $2,500, I can put it right in my operating account. And the answer is no, you can't. There is no $2,500 rule. Forget anything about a $2,500 rule. And trust me on this, if you get a flat fee or payment in advance from a client, put it in your trust account until you can demonstrate on paper that it's been earned. 7, provide some documentation to the file, or if you're using a bookkeeper or an office manager who moves the money between the trust account and the operating account, provide a written memo to that person and copy it to the client to say, move these funds out of the trust account into the operating account. In other words, provide a written statement, I've earned these funds, they can be transferred from the trust account to the operating account. You want to do this within a reasonable time after the fees have been earned. You want to do this, if you don't do it when the fee is earned, do it at least once a month. Set some time aside to do your own client bookkeeping and review the cases that you've handled that past month to determine which cases you've worked on, where you can demonstrate you've earned fees, and prepare your memos or your written documentation to support moving the money out of the trust account into the operating account. And what you want to do is you want to do that no less frequently than once a month. Under DLRPC 1.15A, if you let your earned attorney's fees sit in your trust account for more than 30 days, that's called commingling. When you do this paper documentation or this email to shift the funds out of the trust account into your operating account, you want to copy the client on that memo. The rule for that is DLRPC 1.5F3. Number 8, you can limit the scope of representation in the fee agreement, and I think this is a very fine idea. You should be using form fee agreements, and in your form you should have a sentence that basically limits the scope of representation to the case, and you should specifically identify the case for which you've been retained. That way you don't end up with a client who wants to know why you didn't show up at the real estate settlement when you're their lawyer and you should have known about it. You don't end up with a client who wants to know why you didn't show up for their cousin's felony trial when you were never retained for their cousin's felony trial. Limiting your scope of representation in the written fee agreement is just a good idea, and DLRPC 1.2C lets you do it. So some sample language that you might include in the fee agreement would be, the fee will be for representation during pretrial and trial, one trial, no retrial, in the court of common pleas in the case identified above. Any retrial, appeal, ancillary matter such as a VOP or other cases are outside the scope of the fee agreement. 9. What happens if the fee is paid by someone other than the client? Under DLRPC 1.8F3, you need to advise the payer person making the payment. That the duty of confidentiality is to the client, and they may find themselves paying you to keep secrets from them. You need to advise the payer that their opinions, interventions, and desires may have no interference with your professional judgment or the client-lawyer relationship. That's DLRPC 1.8 F2. And so you need to be very clear with the payer that if they feel that the client should take a plea and the client says, I want to go to trial, your duty is to go to trial, not force the client to take a plea. You see this a lot when you have parents paying for representation of a child. The child may want to take risks that the parents don't think are appropriate. Your duty of loyalty is to the child, regardless of who's paying. Also, you need to have the client give informed consent in writing that the other person is paying for their representation. That comes from DLRPC 1.8 F1. All right, number 10. If funds are obtained from the client for costs, such as hiring a private investigator, obtain written authority from the client prior to incurring those expenses. That comes from DLRPC 1.5B. So you don't want to take $1,000 from the client, you're going to put it in your trust account because it's client property of the client, and you have a duty to safeguard it and keep it separate from your own funds. You don't want to take that money from the client and then spend it and then have the client come back on you and say, I didn't authorize you to do that. I wouldn't have done that. I want that money back. You want to get specific authority from them to make to incur the debt and to pay it. Folks, I'm Attorney Ben Schwartz. These are the 10 things I think that you should know if you're a Delaware lawyer handling criminal or traffic cases. A lot of these things you might notice apply to other cases as well. If you take a retainer and you're going to bill someone for a breach of contract case and you're going to bill by the hour, a lot of these rules still apply. And so my suggestion to you is that you use written fee agreements, that you develop form written fee agreements that encapsulate all 10 of these items. And if you have any questions, send me an email, ben.schwartz@schwartzandschwartz.com. I'm happy. If you're a Delaware lawyer and you would like to see a copy of the form fee agreements that we use in my office, I'm happy to provide them to you. Thanks very much for watching. I hope you found this helpful and informative.